Hello, everyone. Thank you so much for joining in. And my name is Akash Gupta, and I teach arbitration courses at Chandra Global Law School. And today we'll be talking about the basics of arbitration in India. So, without talking too much about myself, so let's discuss the arbitration in India. So, I'll share my screen now, and so that you can see the presentation. Can you see my screen? I hope you can see my screen. Okay, so you can see my screen. So let's go to the presentation and okay, so we are starting now. So this webinar has been actually divided in 5 parts. So the first part will be the introduction to ADR, and the second will be introduction to arbitration, and the third one is trending issues in arbitration. The fourth will be the online quiz, which will be playing online through an app. And the last part will be questions and answers. You can ask me questions. If you have any questions throughout the presentation, please feel free to write on the chat box, and I'll come back to it when we end this presentation. So let's start the presentation now. Okay, so in the first part with respect to the introduction to ADR, we'll be discussing 3 things. The first topic will be the dispute resolution process. The second one is what is adjudicatory and non-adjudicatory process. The third part is what's the scenario with respect to the pending cases in India. So let's go to the first part, and before starting, let's discuss about this, that a quote from Abraham Lincoln, who said, "Discourage litigation, persuade your neighbors to compromise wherever you can. Point out to them how the nominal winner is often a loser in fee, expenses, and waste of time." So if you look at this quote, you'll get a sense why are we talking about ADR, because of course it's less cheap, it's less time consuming, and of course it actually builds upon the relationship which you have with the other party, because you don't move to the court and you resolve the dispute having an independent and a separate body which is not public, which will be confidential in nature. So that's the intro part. Okay, so let's go to the next part of the presentation. So just give me a second. Okay, so we have a technical issue, so just give me a moment to fix it. Okay, so, and the second part is with respect to the 2 dispute resolution process. So if we actually divide the dispute resolution process in 2 parts, the first is actually adjudicatory and the second one is non-adjudicatory. So when you talk about the adjudicatory process, what is it? So it's basically one of the third party, actually an independent party who actually sits on the and decide who will be paying to whom and who is right, who is wrong. However, if you look at the non-adjudicatory process, there is no third party telling who is right, who is wrong. So if you ask me an example with respect to the adjudicatory process, it's arbitration or litigation, where you actually go to the court or you go to an arbitral tribunal and they decide which party should pay to whom. So that's about the that's about the adjudicatory process. And moving to the non-adjudicatory process, it's more about negotiation and mediation, which is more like facilitating both the parties to actually come to a common ground and resolving their disputes. So that's about the dispute resolution process. And there exists a difference in between them. And one of the important part is, in case of adjudicatory process, you actually have a winner and a loser. However, in terms of non-adversarial, you do have sometimes, of course, a winner and loser, but a lot of times the goal is to actually have a win-win situation for both of you. So that's the thing about adjudicatory and non-adjudicatory process. And let's go to the next one. Okay, so why do we actually need ADR? If you look at the Indian courts, the Indian Supreme Court has 1,58,669 cases pending. And if you look at the data with respect to the high courts, you have 43 lakhs cases pending. So going by this figure, what is the end goal of a business entity? So if you look at the big commercial entities, their only goal is, let's say in case they have a dispute, they want to resolve the dispute without affecting their relationship in between the parties. So their actual intention is to resolve quickly without affecting the relationship. And of course, they don't want to go to the courts because it's public in nature. And in a way that will affect their brand value and image. So that's why actually people are moving to arbitration now. And that's why we need to know what arbitration is and how does it work in reality. So that's about the first part with respect to introduction to ADR. So let's move to the next part with respect to introduction to arbitration. So with respect to the second portion of introduction to arbitration, before we move on further, we need to know what actually is introduction to arbitration, like what is arbitration? So if you ask me what is arbitration, arbitration is a dispute resolution process where two parties actually submit to an arbitration meaning an independent private body which is created through the contract, through an agreement in between the parties, and they don't want to actually settle any of their dispute by going to courts. So they want to have a private dispute resolution. That's something which is we call arbitration. And some of the features of arbitration is that the parties themselves decide what should be the rules for arbitration, which law they want to apply to it, and how they actually want to govern this arbitration. And they have also a right to choose the person deciding their dispute. That is, the person deciding the case in an arbitration is called arbitrator. So you have all the rights to choose an arbitrator as well. So let's say if you have a maritime dispute, you choose somebody who's an expert in maritime itself. However, in case of court system, you don't have the choosing option if you cannot choose a judge. However, in arbitration, you have all the rights to choose your arbitrators. So that's about the arbitration. So let's go to the next part with respect to arbitration agreement. So, okay, before going to the arbitration agreement, we need to look at what are the legislations in India which actually governs arbitration. So the foremost and most important law on this subject is Indian Arbitration and Conciliation Act 1996. And this Arbitration Act was actually adopted in 1996, and they actually referred to the 1985 Ancestral Arbitration Law, Model Law. So this UNCITRAL model law was a law which was actually drafted by the UNCITRAL, the United Nations Commission on International Trade Law. And they came up with a model law which can be used by different states to insert within their domestic arbitration act. So India did that, and India adopted UNCITRAL model law. And the other important part was UNCITRAL conciliation rules, because the Indian Arbitration Act provides for conciliation as well within the act. So therefore, India adopted it. And one of the important features of the act is that it also inserted the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958 within the first schedule of the act. So New York Convention basically provides that any signatory country has an obligation to enforce the arbitral award rendered in any of the other signatory countries. So India is also a party to this convention. So that's the background about the arbitration legislation in India. And let's go to the part on section 7, which deals with arbitration agreement. So section 7 provides for the definition and what actually constitutes a valid arbitration agreement. So there are different elements of it. One of them is defined legal relationship, intention to arbitrate, written agreement. However, this written agreement has been interpreted in a way that has been widened by the Supreme Court. And now, after the amendment of the Arbitration Act, even the electronic communications can constitute an arbitration agreement. And here comes the important part, that the decision of the tribunal shall be final and binding. One of the stark difference in between the court system and the arbitration is that after you get a judgment from one of the lower courts in India, you have a right to appeal to, let's say, the High Court or the Supreme Court. However, if you look at the arbitration sphere, you don't have a right to appeal the award. The only thing which you can do is setting aside the award in cases of procedural irregularities. However, the award rendered by the arbitrators on the merits is always final and binding. So let's go to the next part. So this provides that what is the impact of arbitration agreement. So let's assume for a second that two parties entered into an arbitration agreement. What is the effect of it? The effect is that both the parties, let's say if there exists a dispute in future, the only place where they have to go for resolution is arbitration, and they don't have a right to go to court. So there exists a positive obligation to arbitrate any dispute, and they cannot go to the courts. So you actually opt out of the court and you move inside the arbitration regime. So that's the impact of arbitration agreement. And the arbitration agreement, and okay, just before we move further, we have a quiz after I do the brief presentation where I'll be asking you very simple questions with respect to the concepts we discussed now. So yeah, I just forgot to tell you, so I was telling you now. And in one of the Supreme Court judgments, the Supreme Court observed that it's not about how you actually write the arbitration agreement, whether the arbitration agreement is contained within a single document or whether it's contained in different documents, in different email exchanges. The foremost thing to look at is the intention to arbitrate. If there exists a consensus ad idem of the parties to arbitrate any dispute, then the court should give effect to that arbitration clause, and the writing requirement or the signing requirement under section 7 is not a mandatory one. So now it has been widened. So that's about arbitration agreement. So let's move to the next part of jurisdiction of the arbitrator. So where does the arbitrators get the jurisdiction? So it's actually the arbitration agreement, which is the origin of arbitration, as both the parties created this agreement, provided the power to the arbitrators through this arbitration agreement. So let's say if one of the parties is of the view that this arbitration agreement is not valid, so what do? Do you go to the courts to challenge it, or do you actually go to the tribunal? So the rule provided under section 16 is that once you opted out of the court, it's always the arbitral tribunal where you have to move and challenge the arbitration agreement itself, which means the jurisdiction of the arbitrator. And this rule is called competence, that the tribunal themselves have all the rights to decide on their own jurisdiction. The follow-up question can be, what if that the two parties entered into a contract and one of the party alleged that the contract was signed because of a fraud committed by the other party? So there exists a question with respect to the validity of the contract itself, and the contract included one of the clause of arbitration. So what happens in that case? So to safeguard the interest of arbitration, there exists a legal fiction which safeguards this arbitration clause, which provides that in case the contract is invalid, that does not automatically affect the validity of the arbitration agreement. And okay, so okay, so thank you so much, Lakshmi. So let's talk about doctrine of separability. So it provides that even if the contract is invalid, that does not automatically affect the arbitration agreement, which means that the arbitration agreement is separable from the main contract. And even though the contract is invalid, that does not per se affect the validity. And this doctrine is called the doctrine of separability. So, okay, so just give me a moment. So that's about jurisdiction of the arbitrator. And one of the classic case with respect to the doctrine of separability is Fiona Trust. It's an English case. In this case, the court observed that it is not enough to say that the bribery impeaches the whole contract, unless there is some special reason for saying that the bribery impeaches the arbitration clause in particular. So let's say if the party is challenging the contract, the same party has to also challenge the arbitration agreement as well. And there will be two separate inquiries into the validity of the contract and the arbitration clause. So that's about the doctrine of separability. Okay, so let's move a bit further and let's talk about the challenge to arbitrator. Let's say both the parties appointed the arbitrators. However, one of the parties got to know that one of the arbitrator is biased and has a previous relationship with the opposing party. So what happens in that case? So in that case, of course, the parties have a right to challenge it, and that's one of the ground under section 12. So the ground under section 12, one is that it is a justifiable grounds which affects the independence and impartiality of the arbitrator. And the second one is that let's say the parties agreed for a qualification that the arbitrator should possess, the arbitrators don't possess it. So these are the two grounds on which you can challenge the arbitrator. Okay, so let's go a bit further to the conduct of arbitration proceedings. As I already, as I already said, that party autonomy is very important, and it's the creation of parties agreement. So of course the procedure is something which should be decided by the parties. But let's say if the parties have not decided something, then the tribunal gets a right to determine which procedure they should adopt. And whenever they actually adopt a procedure, they have to look into what the parties' agreement was. And of course, the arbitral tribunal has a power to determine the admissibility, relevance, materiality, and weight of any evidence. They have a discretion, a very wide discretion with them. And one of the important part of section 18 is that equal treatment of parties are required. So let's say the tribunal cannot provide 90% of the time for argument to party A and provide 10% of the time to party B, because that affects the equal treatment of parties. And the other point we need to look at is that there should be an equal opportunity to fully present their case. And the last part states that the Indian Evidence Act or the Civil Procedure Code is not applicable in terms of arbitration cases. So that's about the conduct of arbitration proceedings. And moving to the content of awards, of course, the arbitrators should provide reasons to the award, like how they actually come up with this decision and why they have come up with this decision. Let's say if there are three arbitrators and one of the arbitrators is against the conclusion which the other two arbitrators are coming up to. So the minority arbitrator has a right either to sign or not to sign, but that does not affect the validity of the award. So the majority shall sign the award, otherwise the award will not be a valid one. So that's about the form and content of awards. And in case of arbitration, there is nothing like an appeal. So in appeal, you can actually relook into the merits of the case as well as the procedural irregularity. However, in terms of arbitration, what you can look at is only the procedural irregularity. So let's say one of the parties didn't get a chance to fully present its case. So you can go to the concerned court and you can ask for setting aside of award. Setting aside of award merely means that the effect of award in that jurisdiction will be taken away by the court. It's that simple. However, setting aside is different and appeal is different. And in terms of arbitration, you don't have an appeal. So that's about the setting aside procedure, and you have grounds mentioned under section 34 of the Act, which is almost similar to Article 34 of the Unset Trial Model Law. So these are the grounds. One of them is incapacity of a party to sign an arbitration agreement. Second is the arbitration agreement's invalidity, improper notice of the appointment. And the important part is part G, which provides that if the arbitral award is in conflict with the public policy of India. So a lot of cases we have seen in India that the Indian Supreme Court has exercised this power and held that the award was against public policy. So that's about the setting aside procedure. And one of the important concepts which we should look at is the arbitration seat. So an arbitration always work. Okay. So an arbitration is given effect, has been provided a legal sphere by the seat. Where is it, where the arbitration is happening? So that's called the seat. So by meaning that the seat is India, it means that the Indian Arbitration Act will be applicable and the supervisory jurisdiction will be with the Indian courts. And let's say if the other party wants to get an interim measure or they want to set aside, you move to the seat. However, if the parties decide that the seat is India, they may decide that they want to conduct the hearings outside India, let's say Singapore. So seat is different. However, place of arbitration, seat is also called as place of arbitration, but venue is something where hearing is happening, and venue does not have a bearing on arbitration. So that's about the arbitration seat. And we have discussed about the effects that the arbitration law of the seat will be applicable, and the setting aside interim measure, you have all the rights to move to that court. So let's move to the third part of trending issues in arbitration. Okay, so I have some questions which I'll be coming at the end of the presentation after the quiz. So yes. So let's talk about the trending issues in arbitration. So there are different issues and we'll be covering some of them because of the time limit. So let's start with the first one. So one of the trending issues is that whether a non-signatory to arbitration can be impleaded into the arbitration, whether a third party or a non-signatory can be also a party to the arbitration proceeding. So let's say two parties, party A and party B, signed a contract. Party A had a parent company which played actually a very important role in discussing and negotiating the deal with party B. So whether the parent company can also be impleaded to that arbitration proceeding. So before 2013, the Indian courts were skeptical about it. However, in 2013, the Supreme Court in the case of Chloro Controls decided that the non-signatories can also become a part of the arbitration proceeding under exceptional cases where the composite transaction test is fulfilled. So that's about non-signatory. Let's move to the issue of arbitrability. What do you think? Do you think all the disputes are arbitrable? So let's say the criminal matters, or let's say the matrimonial disputes of divorce, do you think it's arbitrable? The answer is no, it's not arbitrable. Not all the disputes are arbitrable actually. However, the Indian courts does not provide that what disputes, the Indian Act does not provide which disputes are arbitrable and which disputes are not arbitrable. So what happens is that the court interpretation is something which we actually look at. So the test has been provided by the Supreme Court in the case of Booz Allen Hamilton versus SBI Home Finance. So in this case, the Supreme Court laid down the test that if there exists a dispute with respect to right in personam, meaning that the right against a person, then the issue at hand is arbitrable in nature. However, if there exists a dispute involving right in rem, right against the whole world, it's not arbitrable. So that's the test which we need to look at. Just to give you an example, in one of the cases where the copyright disputes was with respect to a license, which was right in personam, the Supreme Court, the High Court actually held that this dispute is arbitrable. However, in the other case where the right in rem was not, where the right in rem was involved and it was not a right in rem, the court held that it's not arbitrable. So let's move a bit further that what disputes are not arbitrable. So in one of the Indian cases, the Supreme Court held that when you have a specialized body like a consumer forum or National Company Law Tribunal or Competition Commission of India, then those disputes are non-arbitrable. However, the other examples provided by the court was matrimonial disputes, guardianship matters, and cases involving trust. So these disputes are not arbitrable. Let's look at some of the pro-arbitration approach and the recent amendments. So one of the recent judgments actually designated MCIA, the Mumbai Center for International Arbitration, as the appointing authority, which was welcomed by the international arbitration experts. So that was one of it. And let's talk about the amendments in 2019. So one of the amendments was reducing the time limit. And now the time limit is 12 months, which can be further extendable by 6 months. And the third point is fast track procedure. Even though the Indian Arbitration Act does not insert a provision for emergency arbitration, it actually provides for fast track procedure, which has a 6 months time limit, and it does not have oral arguments if the parties agree so. And the second last point is that the applications for the appointment of arbitrators should be disposed of within 30 days. And one of the pro-arbitration approach was inserting a provision with respect to confidentiality. And this was inserted under 42A of the Act. So that's about the pro-arbitration approach. And one of the issue is pathological clauses, and pathological clauses mean poorly drafted clause which has some defects to it. So just to give you an example, let's say if the parties have written in the agreement that they'll go and settle the disputes under the aegis of Singapore Chamber of Commerce. However, the Singapore Chamber of Commerce is not an existing institution, and this issue goes to the court. So in one of the cases, the Supreme Court referred the parties to arbitration under Singapore International Arbitration Center and actually held that this clause was workable, and therefore the intention to arbitrate should be given effect. So that's about pathological clauses. And let's go to the next part, emergency arbitration. So emergency arbitration is something which has a very tight timeline, let's say 15 days to decide an arbitration. It's like before conducting the full arbitration, you do the emergency arbitration to get the interim measure or interim remedy out of it. So that has been provided under different arbitration rules such as ICC, CIAC, LCIA, SCC. Even the Indian rules, let's say Indian Council for Arbitration Rules and Mumbai Center for International Arbitration Rules provide for it. Even though the Law Commission report number 246 in 2014 suggested to include EA, however, it has not been included either by 2015 amendment or the 2019 amendment. And the Indian courts are has a divergent view. One of the courts, that is Bombay High Court, relied upon the emergency arbitration to grant an interim measure. However, the Delhi High Court rejected to enforce an emergency arbitration award. So that's the scenario about emergency arbitration in India. And one of the important things to look at is IBA guidelines on the conflict of interest in international arbitration. So these guidelines help you to decide whether the arbitrator is in a conflict with the parties involved. So it provides for three lists: green, orange, and red. So green is good to go, orange is doubtful, red that you shouldn't go, but it has a waiver, it has a waivable list as well as the non-waivable one. So this guidelines was actually relied upon by the Delhi High Court in one of the cases in 2012, and this has been also incorporated under the schedule of the Indian Act, which is a good thing that now the Indian Arbitration Act is coming in line with the international arbitration standards. So let's go to the next part. And one of the amendments in 2019 provided for the qualification of arbitrator, which provides that an advocate should have an experience of 10 years, or let's say even if you are an engineer or a subject expert like chartered accountant, company secretary, you need to have a 10 years experience, which was criticized by a lot of international arbitration experts because it will actually affect it. The effect of it can be seen that it closed the door for the newcomers to the arbitration. So that's the part about the qualification of the arbitrators. Okay, so okay, I'll be coming back to the questions involved. So before that, let's just I'll be just briefly finishing A, then we have a quiz, and after the quiz, I'll be coming back to the question and answers, and I'll be taking all your questions from the chat box. So, okay. So one of the things which we should actually also look into is whether the foreign lawyers are allowed to take part in the international commercial arbitrations. The answer is yes, and this was decided in one of the Supreme Court judgments in 2018. However, the foreign law firms or the foreign lawyers are not allowed to practice in India. The only way they can practice is after they are registered under the Indian Advocates Act, but they may fly in, fly out to advise on the issues of foreign law on a casual basis, but cannot be coming down to India frequently because that will actually amount to giving legal advice or representing the clients in the cases. So therefore, the Supreme Court had an option to actually remove the bar from the foreign lawyers or the foreign law firms to enter the arbitration proceeding as well as the litigation. However, the Indian Supreme Court was of the view that this is not the time to actually remove this bar, and the foreign lawyers are not allowed to represent the clients in front of the courts. The only way they can do it is advice, or they can take part in the international commercial arbitration. So that's about it. And okay, so let's look at some of the arbitration institutions in India. The most famous one and functional one is Mumbai Center for International Arbitration and Nani Palkhiwala Arbitration Center, which has a branch in Chennai and New Delhi. So that was the basics with respect to the arbitration. And so let's go to the next part with respect to the quiz. Okay, so I want you to actually go to this website called kahoot.it, and I'll show you the pin which you have to enter, and then we'll play the quiz. So this is how it works. So you'll see the questions on this screen, and you have to answer from your mobile phones or any other device through which you are logging in. So, okay. So if you have already been to Kahoot, so let's start. So you have to go to this website called kahoots.it, and you can see the pin right there on the screen, which you have to enter to log into this game. I'm sharing this on the chat box as well. Okay, so I see people joining in. So this is how you actually play this game. So you enter the quiz room with this pin. You have to go to this website, kahoot.it, put this pin, write your nickname, and you just log in. Okay, so for every questions, you'll get 10 seconds to answer. So the question will come on the screen. It'll give you like 2, 3, 4, 5 seconds. And then after a point of time, you'll see the options at different colors. And you have to answer from your mobile phones. You'll be seeing the symbols, different symbols of different options. So just look at the options and then answer, and you'll be fine. It's super easy. Okay, so I see almost 50 participants, but we see only 22 of them on Kahoot. So we'll wait for another minute and then we'll start. Okay, I don't see people logging in, so I'm not sure I should start or should we wait for another 2 minutes? Okay, so we see people logging in. Okay, so can we start or okay, I'm still seeing people logging in, so okay, we'll start right after 1 minute. Okay, so let's start because I don't see new people coming in. So the quiz is already started. So all the best. Okay, so remember when we started this session, we talked about this, that in adjudication, you have an independent body and deciding who is right and who is wrong. However, in case of non-adjudicatory, there is no one telling who is right, who is wrong, and making a decision. There is nothing like a decision because they just facilitate you to discuss and resolve the dispute. So arbitration is an adjudicatory process. Okay, so let's move to the next question. And if somebody has just joined, then please go to kahoot.it And this is the game pin which you require to log in, because we are playing a quiz, so that you can enter. Okay, so let's go to the next question, and we see the scoreboard right here on the screen. And every time the scoreboard gets updated right after the question. So let's go to the next one. Okay, so this is impressive that still there are some 9 people who think that it's not that India adopted ancestral model law. However, the case was like, if you look at the 1996 Act, it was actually based upon the ancestral model law, and India has taken a lot of provision and inserted that into the Domestic Arbitration Act, which is the Indian Arbitration and Conciliation Act. So please keep in mind that India adopted the ancestral model law on ICA, as well as India inserted the New York Convention under the Indian Act. So, okay, just give me a moment. Okay, so if you are new to this webinar, you have to go to this kahoot.it, and the game pin is here and you log in. So let's go to the next question, and we see a lot of changes in the scoreboard. The third question is on the screen. Okay, so of course, New York Convention deals with foreign awards and not the domestic awards, because for the domestic awards, the Indian Act is applicable with, and also India has inserted this to give effect to the foreign awards. So New York Convention deals with foreign awards. So let's go to the next part. Okay. The fourth question is on the screen. Yes, the most important part is intention to arbitrate. If intention to arbitrate consensus addendum is there, then even though if it is not contained in one of the single documents, it's in different correspondences, it doesn't matter. At the end, there exists an intention to arbitrate, and therefore it's a valid arbitration agreement. So let's go to the next part. Yes, the right answer is that a non-signatory can be impeded to arbitration, because we have a case chloro controls, and which was also amended later by the 2019 Amendment Act. The definition of party has been widened. So let's go to the next question. Okay, so the only right in personam disputes are arbitrable and not the right in rem. And of course, not all the disputes are arbitrable in nature, because you do have some of the company law matters whose jurisdiction actually is coming under the NCLT, and there exists a consumer forum for consumer disputes. So not all the disputes are arbitrable. And I see new people coming in. So what you have to do is you have to go to this website, kahoot.it. At the down, you can see it. And then the game pin is given. You have to log in with this. So let's go to the seventh question. Yes. Okay, as we discussed that venue is not something which matters the most, and arbitrator's nationality, of course, it doesn't matter which country the arbitrators are coming from, and law applicable to the contract is required to resolve the disputes, the merits of the case. However, the seat is very important because seat is something which provides the legal sphere to arbitration. And let's say if you have any issue, you go to the courts at seat. So that's about seat. And let's go to the next question. As we discussed from one of the Supreme Court judgments that the pathological clauses are can be workable arbitration clause if the Supreme Court is of the view that they can rectify the error made by the drafter. So so previous to 2019 amendment, the Indian Act did not expressly provided for confidentiality. However, after the 2019 amendment came, so section 42A provides for confidentiality. So let's go to the next question. Okay, so that was the last question, and thank you so much for this feedback. And let's go to the scoreboard. Okay, so okay, so that was about Kahoot, the quiz, and let's go to the next part and let's see the questions. Okay, so somebody asked this question that what is the difference between an arbitration clause and an arbitration agreement? These things differently. Okay, so one of the thin line of difference in between arbitration clause and an arbitration agreement is, let's say you have a contract which has 100 of clauses, and one of the terms of the contract, one of the clause provides for arbitration. That's more like an arbitration clause. However, that also can be called as an arbitration agreement, but some of the authors say that arbitration agreement is something different and the parties independently agree to arbitration in a separate form of agreement. So that's the thin line of difference. However, if you ask technically, there is no difference in between arbitration clause and arbitration agreement. And we have another question that can it be argued that in case the proceedings are not decided, the rule of CPC is applicable in spirit? Okay, guys, the default rule is that CPC or Indian Evidence Act are not applicable because of the reason that the parties opted out for court system as well as the complex legal system of a country. Because when parties opt for arbitration, they want to govern the arbitration proceeding by their own rules or by an arbitration rules. So therefore, the CPC or Indian Evidence Act is not applicable to it. Okay. What is included under the arbitral award? So basically an arbitral award is more like what you see in terms of the Supreme Court judgments. However, it's not that long, but it provides for all the details, what has been argued, what does the arbitrators think, what is the majority, in case if there exists a majority or minority, and they explain why they have reached that decision, which is the most important part. And the arbitral award has the signature of all the arbitrators. Let's say if one of the arbitrators are not willing to sign, the minority, it's up to them, but that does not affect the validity of the award. Okay, so Akash has a question that the arbitration clause has its own existence and we choose arbitration as a method to resolve the dispute related to contract. But if the contract itself is void, then what is the meaning of arbitration clause? Okay, so this is one of the contrary opinions with respect to the doctrine of separability. But in some cases, what happened, just to get away with the obligation to arbitrate, the parties actually allege that the contract is invalid. So let's say if they allege that the contract is invalid, that shouldn't be affecting the independent investigation of the arbitration agreement. And there are judgments on it by the Supreme Court. So let's say Ayasami judgment, which provides that mere fraud allegation does not affect the arbitration agreement. So in those cases, if there exists an automatic effect on the arbitration agreement, that will at the end affect the arbitration, the intention to arbitrate of the parties. So that's about the separability. And okay, so what is the qualification of arbitrator in India? Okay, so one of the schedule of the Indian Act provides for qualification and experience of arbitrator, and that provides that if you are an engineer, you should have 10 years of experience in that field. So that has been criticized by a lot of international arbitration experts, that it actually restricts the number of people coming into the arbitrator's pool, but that's the law in the present case. Okay, so whether emergency arbitration should be allowed in case of submission agreement. Yes, there is no question with respect to allowing it. The problem is that what happens if you have an emergency arbitration award in India? It's not certain whether you can enforce it or you cannot enforce it. Of course, if the two parties are willing to submit to emergency arbitration, they have all the rights to do that. But the problem is what happens after you have an emergency arbitration award. So that's a gray area and nobody has an answer because it's still the Indian courts have divergent views on this issue. And Harsh has a question with respect to designation of a particular seat. How can the seat be determined if the parties themselves do not designate a seat? Okay, so I'll give you an example. So let's say the two parties don't write in their arbitration agreement what is the seat for arbitration. So in those cases, either the parties later on decide what seat they want to go for, or if they don't decide and it's an institution rules which they have actually accepted. So let's say if they say that MCIA or AIAC is Asian International Arbitration Center in Kuala Lumpur, Malaysia. So they contain a default rule that the moment you choose this arbitration rule, Kuala Lumpur will be the seat. So sometimes when the parties don't choose it, it goes to the arbitration center rules. And let's say if the arbitration center does not have a rule on that, then the arbitral tribunal themselves decide with respect, of course, keeping in mind the parties' autonomy and parties' agreement. So that's about the question with respect to the seat. And okay, so Kirti has a question. If there is an arbitration clause in an insurance contract, can the policyholder approach the court neglecting the arbitration clause? Will the Indian courts have jurisdiction to try such cases? So if the insurance contract, if the insurance policy had a clause, the arbitration clause, which has been negotiated, which has been discussed, and which was actually known to the person who actually holds the policy, in that case, that constitutes a valid arbitration clause because there exists a consensus addendum. So you cannot move to the court. However, in another case, so let's say in one of the long TNC of the insurance policy, there contains one small clause on arbitration clause, which was not aware to you, then you may move to the court and argue out that this arbitration clause was something which I never intended to agree. I was unaware of it. So in those cases, the courts will try it out, but you need to prove that there was no intention to arbitrate, because by signing, there exists a presumption that you actually consented to arbitration. Okay, so Prabhu has a question. How young advocates can enroll with Arbitration Center? And please share some arbitration centers so that we can become member. So if you look at the last part of the presentation. So there are different arbitration centers in India which have different programs. They have accreditations, and in that you can actually sign up and you can become a certified mediator or arbitrator. So if you look at Indian Institute of Arbitration and Mediation, they have a 40 hours course which actually provide for an accreditation. And so what happens basically that after this 2019 amendment, it's not very easy to be appointed as an arbitrator, because the default rule under the act is actually to have a 10 years experience. However, you can do the accreditation courses and you can look into the ODI platforms, the online dispute resolution platforms like SAMA or let's say Presolve 360, where you can sign up as an arbitrator or as a neutral or as a case manager. So, okay, so that's about the question and answer. So I hope we have covered all the aspects of the session. So somebody has Anjali has a question. In matters where one of the parties is a foreign party and the parties choose to resolve their disputes through arbitration at a place outside India, can the state high courts intervene in such matters? The answer is no. If it's just through at a place outside India, no, because the seat is outside India and the Indian courts does not get power. Only under the exceptional cases they get the power. For example, if there exists an interim measure which has to be provided, and let's say the Indian company is going to sell its assets and the Indian company is a part of an arbitration seated in Singapore. So of course the Singaporean company can come to India and ask for an interim measure, but the Indian courts does not get the power to set aside the award or interfere unless until the parties ask for it, and which has been accepted under the Arbitration Act, that is Section 9, Section 27. Okay, so we see that our time is running out. So if you have further questions, please feel free to drop the questions on my LinkedIn, which is this one, or my email, and I'll try to answer all your questions because our time is up. And so, okay, so I request you to please send me your questions if I couldn't answer your question now. And now we are over time. So thank you so much for joining in. And please feel free to write me your questions and I'll try to answer as soon as possible. So thank you so much for joining in. Stay safe, stay home. Thank you.